Directors, trustees, and officers under the Revised Corporation Code Part 1. Qualifications, elections, independent directors, term, removal, and vacancy. The Revised Corporation Code of the Philippines, Republic Act No. 11232, establishes the legal framework for directors, trustees, and officers of corporations. These provisions ensure good corporate governance, accountability, and protection of stakeholders. Understanding these rules is essential for bar examinees, as questions on corporate governance frequently appear in the bar exam. Qualifications and Disqualifications. Section 23. Directors of stock corporations must own at least one share of the corporation's capital stock. Trustees of non-stock corporations must be members of the corporation. Section 26. Grounds for disqualification include: 1. Final conviction of a crime punishable by imprisonment exceeding 6 years. 2. Violations of the Corporation Code or Securities Regulation Code. 3. Fraudulent acts resulting in administrative liability. 4. Similar violations adjudicated by foreign courts. Example: a person convicted of estafa, punishable by imprisonment exceeding 6 years, within 5 years before election, is disqualified from serving as a director or trustee. Jurisprudence Lim v. Moldex Land, Inc., 2017. The Supreme Court held that only stockholders or members of record can be elected as directors or trustees, reinforcing Section 23 requirements. 2. Elections of directors and trustees. 1. Section 22 of the Revised Corporation Code provides that directors are elected for a term of 1 year from among the stockholders of record. Trustees in non-stock corporations, on the other hand, may serve for a term not exceeding 3 years. 2. Section 23. Election of directors, trustees requires a majority of the outstanding capital stock or voting members to be present. Voting can be: 1. In person, 2. By proxy, or 3. Through remote communication, if allowed by the bylaws. Voting methods. 1. Straight voting. A stockholder casts all their shares in favor of each candidate. 2. Cumulative voting. A stockholder may concentrate all votes on one candidate or distribute them among several candidates. Voting in non-stock corporations, members can cast as many votes as there are trustees but cannot give more than one vote per candidate unless bylaws allow it. Quorum and election requirements. 1. A majority of the outstanding capital stock or members entitled to vote must be present, in person, by proxy, or via remote communication, to constitute a quorum. Elections must be conducted by ballot upon request of any voting stockholder or member. Jurisprudence Tom v. Rodriguez, 2015. The Supreme Court ruled that management and control of a corporation rest with its duly elected board, highlighting the importance of valid elections. 3. Independent directors. Section 22. Corporations vested with public interest, such as publicly listed companies and banks, must have independent directors. An independent director is a person who, apart from shareholdings and fees received from the corporation, is independent of management and free from any business or other relationship which could reasonably be perceived to materially interfere with the exercise of independent judgment in carrying out the responsibilities as a director. The RCC defines corporations vested with public interest to include corporations covered by Section 17.2 of Republic Act No. 8799. Securities Regulation Code, namely A. Those whose securities are registered with the SEC, B. Corporations listed with the stock exchange, or those with assets of at least $50 million and having 200 or more stockholders, each holding at least 100 shares of a class of its equity shares. Note that it is not enough to have assets of $50 million. The corporation should also have at least 200 stockholders, each holding at least 100 shares. Also included as corporations vested with public interest are, of course, banks and quasi-banks, non-stock savings and loan associations, pawnshops, corporations engaged in money service business, pre-need, trust and insurance companies, and other financial intermediaries. Under RCC, corporations vested with public interest have the following additional obligations. They are required to have independent directors comprising at least 20%, but not less than 2 of the entire board. They are required to have a compliance officer. They are required to have its material contracts with self-dealing directors approved by at least 2/3 of the entire membership of the board, with at least a majority of the independent directors approving the same. They are required to submit to the Securities and Exchange Commission, SEC, and shareholders a director's compensation report. They are required to submit a report on director or trustee appraisal or performance report and standards or criteria used to assess each director or trustee, and they may be required to have an independent transfer agent. Key concepts. 1. Definition. An independent director has no business or professional relationship with the corporation that could affect their independent judgment. 2. Election. Elected by shareholders, including those voting in absentia. 3. Minimum requirement. Publicly listed corporations must have at least 2 independent directors or 20% of the board, whichever is higher. IV. Term, holdover, and removal. Under Section 22 of RCC, directors are elected for a term of 1 year and shall hold office until their successors are elected and qualified. The term of directors is distinct from their tenure, which refers to the actual period they serve in office. A director's tenure may extend beyond the 1-year term if they serve in a holdover capacity, pending the election and qualification of their successors. If a director's term expires but no election is held, they remain in a holdover capacity until a valid election takes place. The holdover period is not considered part of the director's term. This was clarified in Valle Verde Country Club, Inc., et al. versus Africa, GR number 151969, 2009, where the Supreme Court ruled that the term of office is fixed by statute and does not include the holdover period. Interactive exercise hypothetical scenario. ABC Corporation held its annual stockholders meeting on January 1, 2024, and elected a new board of directors. However, due to internal disputes, no election was held on January 1, 2025. The directors continued to serve in a holdover capacity. On March 1, 2025, the stockholders elected a new board. Question. 1. What is the term of the directors elected on January 1, 2024? 2. Is the holdover period part of their term or tenure? 3. Who has the authority to fill vacancies in the board during the holdover period? Suggested answer. 1. The term of the directors elected on January 1, 2024, is 1 year, ending on December 31, 2024. 2. The holdover period from January 1, 2025, to March 1, 2025, is part of their tenure, not their statutory term. 3. During the holdover period, vacancies in the board may be filled by the stockholders, as emphasized in Valle Verde Country Club, Inc., et al. versus Africa, GR number 151969, 2009. Removal of directors, Trustees Section 27, Republic Act number 11232. This section outlines the procedure for removing directors or trustees, including the required vote, notice, and meeting protocols. Removal may be with or without cause, provided that the process adheres to the requirements of the law. Key requirements for removal. 1. Vote threshold. A director may be removed by a vote of at least 2/3 of the outstanding capital stock, for stock corporations, or 2/3 of the members entitled to vote, for non-stock corporations. 2. Meeting requirement. The removal must occur at a regular meeting or a special meeting called specifically for this purpose. 3. Notice requirement. Stockholders or members must be given prior notice of the intention to propose the removal, including the time and place of the meeting. 4. Limitations. Removal without cause cannot be used to deprive minority stockholders of their right to representation under Section 23 of the Revised Corporation Code. Directors who are disqualified under Section 26, e.g., due to criminal conviction or administrative liability, may also be removed. In Bernes et al. Versus Cinco et al. GR numbers 1633557, 2015. The removal of directors was declared invalid because the meeting was improperly called by the Oversight Committee instead of the President or Secretary. This case underscores the importance of strict compliance with procedural requirements. In Raniel, et al. Versus Hochiko, et al. GR number 153413, 2007, the removal of directors was upheld because it was based on valid grounds, e.g., delays in releasing medical supplies, and followed the proper process. This case demonstrates that removal with cause is a valid exercise of corporate powers. Sample bar question. Question. A director of XYZ Corporation was removed during a special stockholders meeting called by a group of minority stockholders. The director claims that the removal is invalid because the meeting was not called by the president or secretary. Is the removal valid? Explain. Answer. The removal is invalid. Under Section 27 of the Revised Corporation Code, a special meeting for the removal of a director must be called by the secretary upon the order of the president or upon the written demand of stockholders representing at least a majority of the outstanding capital stock. In Bernes et al. Versus Cinco et al. GR numbers 163355657, 2015, the Supreme Court held that failure to comply with this requirement renders the removal invalid. Hypothetical scenario. ABC Corporation has a board of directors composed of 10 members. During a regular stockholders meeting, stockholders representing 70% of the outstanding capital stock voted to remove one of the directors without cause. The director argues that the removal is invalid because no specific grounds were cited. Is the removal valid? Proposed answer. The removal is valid. Under Section 27 of the Revised Corporation Code, a director may be removed with or without cause, provided that the removal is approved by at least 2/3 of the outstanding capital stock and conducted during a regular or special meeting with proper notice. The absence of specific grounds does not invalidate the removal, as long as the procedural requirements are met. V. Vacancy in the Board of Directors. 1. Section 28. Vacancies may be filled by the remaining directors if a quorum exists, except in cases of 1. Removal, 2. Expiration of term, 3. Resignation, death or incapacity, and 4. Increase in board size. 2. The method of filling the vacancy depends on the cause, by the remaining directors. If the vacancy arises for reasons other than removal or expiration of term, and the remaining directors still constitute a quorum. By the stockholders or members, if the vacancy arises due to removal, expiration of term, or if the remaining directors cannot constitute a quorum. Section 29. A director or trustee elected to fill a vacancy serves only for the unexpired term of the predecessor. Key concepts. 1. If a director resigns, dies, or becomes incapacitated, the board may appoint a replacement if a quorum exists. 2. If a director is removed, the vacancy must be filled by stockholders or members at a regular or special meeting. Example: if a director resigns and the remaining board members still form a quorum, they may appoint a replacement. However, if a director is removed, stockholders must elect the replacement. In Valle Verde Country Club, Inc. vs. Africa, GR number 151969, 2009. The Supreme Court emphasized that vacancies caused by the expiration of a director's term must be filled by the stockholders, not the remaining directors. This ruling underscores the principle that directors derive their authority from the stockholders, who have the exclusive right to elect their representatives. 2. Lim vs. Moldex Land, Inc., 2017. The Supreme Court clarified that only qualified individuals can fill board vacancies, reinforcing compliance with corporate law. Conclusion: understanding the qualifications, elections, term, removal, and vacancies of directors is critical for bar examinees. 1. Study sections 22 to 31 of the Revised Corporation Code. 2. Familiarize yourself with these key Supreme Court cases. Practice applying the rules through hypothetical scenarios. If you found this video helpful, don't forget to like, share, and subscribe to our channel for more legal insights. Feel free to leave your questions or comments below. Thank you, and good luck with your studies.